Hello. First of all, we want to thank all our men and women in uniforms for serving our country, including the ones present here. Andrew Tingen, U.S. Army veteran, Randy Lopez, U.S. Navy veteran, and James Tuck, U.S. Marine Corps veteran. In this panel, we will discuss veterans' rights and education, including federal and state law and federal benefits programs. We will begin by talking about what many of us know about, the GI Bill. Randy, what is the post-9/11 GI Bill and how is someone eligible for it?
So the post-9/11 GI Bill will pay for resident or all resident tuition and fees for a public school, the lower of the actual tuition and fees or the national maximum per academic year for a private school for eligible veterans. In order to be eligible for the post-9/11 GI Bill, veterans who have at least 90 days of aggregate active duty service after September the 10th, 2001, and are still on active duty, or if they are an honorably discharged veteran or were discharged with a service-connected disability after 30 days, may be eligible for this VA-administered program.
All right. Now, it is important to note that the post-9/11 GI Bill has specific components like the Yellow Ribbon Program and the transfer of entitlement option. What exactly is the Yellow Ribbon Program and who is eligible for it?
So the Yellow Ribbon Program doesn't cover all school tuition and fees. It has funds that cover all mandatory fees for a student's program of education, even for non-full-time students. Other non-mandatory fees such as room and board, study abroad, or penalty fees such as late registration are not payable under the program. Individuals who have served an aggregate period of 36 months in active duty after September the 10th, 2001, or were honorably discharged from active duty for a service-connected disability and served 30 continuous days after September the 10th, 2001, or individuals that are dependents eligible for transfer of entitlement may be eligible for this Yellow Ribbon Program.
So what is the process to apply for the Yellow Ribbon Program?
So in order to apply, individuals who are at the 100% benefit level and who submit an application for the post-9/11 GI Bill to the VA will then issue them a certificate of eligibility, advising them of their potential eligibility for the Yellow Ribbon Program. Then the individuals should submit the certificate to their school, and their school will determine if there's availability for this Yellow Ribbon Program based on the school's agreement with the VA.
All right. Now, Andrew, can you tell us about the second component of the post-9/11 GI Bill, the transfer of entitlement option?
Yes, sure. So the transferability option under the post-9/11 GI Bill allows service members to transfer all or some of their unused benefits to a spouse or a dependent child. And the determination is made by the Department of Defense, and then those new beneficiaries can apply through the VA's website.
Okay. So what is the type of assistance that eligible service members can get with this transferability option?
So eligible service members can transfer all or a portion of their unused 36 months of the post-9/11 GI Bill to a dependent spouse or to a child. They may transfer these benefits if they're eligible in a combination of sorts to both a child and or that dependent spouse.
Good. So how many people can be eligible for the option?
Well, I'll start first with the service member, and then I'll go on to the family members. So for the service member, they must be a member of the Armed Forces, active duty, or selected reserve. They can be officer or enlisted and be eligible for the post-9/11 bill. After they meet that criteria, the DoD will then decide if they're eligible for the post-9/11 GI Bill. If they are, then they can transfer those benefits to a dependent. The family member, all that the family member needs to do is to be enrolled in DEERS or the Defense Eligibility Enrollment Reporting System and be eligible for benefits at the time of the transfer.
Okay. Do transferors retain the right to revoke or modify a transfer?
Yes, they do. So transfers retain the right to revoke or modify the transfer. If they've designated a spouse or a transferee or a child as a transferee, then they retain the right to revoke it or modify at any time.
Okay. When can family members use the transferred educational benefits?
Yes, so spouses can start to use the benefit immediately They do have a 15-year limit to use that after the service member exits service. And while that service member is on active duty, they would not be eligible for any housing allowance that's attached to the benefit. For children, the service member has to have served for at least 10 years before that child is eligible to be designated as a transferee. The child then needs to, or I guess in conjunction with that requirement, needs to be at least 18 years of age and have obtained a secondary degree or a secondary diploma, or the equivalent thereof. Something like a GED would qualify for that. The children are not subject to the 15-year limit that the spouse has, but they do have to use it by the time they reach 26 years of age.
Great. Now for those of us in Texas, James, let's talk about the Texas Hazelwood Act. What is the Texas Hazelwood Act, and what does it provide for veterans?
The Hazelwood Act is a state of Texas benefit that provides qualified veterans, spouses, and dependent children with educational benefits of up to 150 hours of tuition exception, including most fee charges at public institutions of higher education in Texas, like public colleges and public universities. This act does not include living expenses, books, or supply fees.
All right, so what are the qualifications that veterans must meet for the Texas Hazelwood Act?
During the time of entry into active duty in the United States Armed Forces, veterans must designate as a Texas resident, enter service in Texas, or designate Texas as the home of record, have received an honorable discharge or separate under honorable conditions as found on the Veteran's Certificate of Release or discharge from active duty, your DD-214, have served at least 181 days of active service, including training, have no federal veterans education benefits or veterans education benefits dedicate to payment of tuition and fees, not be in default of a student loan, enroll in classes for which the college receives tax support, and meet the institution's satisfactory GPA requirements by the institution's financial aid policy. And if a veteran is an undergraduate student, he or she must not be considered to have attempted an excessive amount of school credit hours.
All right, can the Hazelwood Act apply to a veteran's spouse or child?
Yes, spouses and dependent children of eligible active duty, reserve, and Texas National Guard who become totally disabled for purposes of eligibility as a result of a service-related injury or illness, are missing in action, or have died during service, or as a result of injury or illness directly related to military service, are entitled to each receive 150 credit hours exemption if they meet certain qualifications as outlined in the Hazelwood Act.
Okay, Randy, can you explain another option that veterans have, the Montgomery Bill Active Duty, or MGIB?
Sure. The MGIB-AD program, often referred to as Chapter 30, provides education benefits to veterans and service members who have at least 2 years of active duty. Eligible service members may receive up to 36 months of education benefits under that program.
What type of assistance does the MGIB-AD program provide to veterans?
So this program provides assistance to veterans that may be used for technical or vocational courses, flight training, apprenticeships, or on-the-job training, high-tech training, licensing and certification tests, entrepreneurship training, certain entrance examinations, and correspondence courses, or college degree and certificate programs. Deficiency, refresher, or remedial courses may also be approved under certain circumstances. Benefits are generally payable for 10 years following an individual's release from honorable active service.
What about the MGIB-SR program? What is it exactly?
So the MGIB-SR program is for reservists with a 6-year obligation in the selected reserve who are actively drilling. MGIB-SR program provides education and training benefits paid by the VA to eligible members of the selected reserve, including the Army, Navy, Air Force, Marine Corps, and Coast Guard Reserve, and the Army National Guard and the Air National Guard. Eligibility for this program is determined by the selected reserve components. A veteran's eligibility for the program typically ends the day the veteran leaves the selected reserve.
What type of training does the MGIB-SR program provide to veterans?
So the MGIB-SR program provides assistance that may be used for co-op training, technical or vocational courses, flight training, apprenticeships, or on-the-job training, high-tech training, licensing and certification tests, entrepreneurship training, certain entrance examinations, and correspondence courses and college degree and certificate programs. Deficiency, refresher, and remedial courses may also be approved under certain circumstances.
Now, on to our last topic, the Vocational Rehabilitation and Employment Program. Andrew, what services does the Vocational Rehabilitation and Employment Program offer?
Yes, the Vocational Rehabilitation and Employment Program provides services such as comprehensive evaluations to determine abilities, skills, and interests for employment, vocational counseling, rehabilitation planning for employment services such as job training, job-seeking skills, resume development, and other work readiness assistance. Assistance with funding and keeping a job, including the use of special employer incentives and job accommodations, on-the-job training, apprenticeships, non-paid work experiences, post-secondary training at college, vocational or technical or business schools, supportive rehabilitation services, including case management, counseling, medical referrals, and independent living services for veterans with severe disabilities who are unable to work.
That sounds really good. Who is typically eligible for the Vocational Rehabilitation and Employment Program services?
Yes, so active duty service members are eligible if they expect to receive an honorable or other than dishonorable discharge upon separation of active duty, obtaining a memorandum rating of at least 20% or more from the Department of Veteran Affairs, and apply for vocational rehabilitation and employment program services.
Are veterans eligible for vocational rehabilitation and employment program services too?
Yes, they sure are. So veterans are eligible if they've received a discharge that's other than dishonorable and have a service-connected disability rating of at least 10% from the VA, and if they apply for vocational rehabilitation and employment program services.
Okay. James, let's talk some more about eligibility under this program. How do individuals obtain eligibility for the program?
Well, the basic period of eligibility ends 12 years from the day of notification of one of the following: date of separation from active military service, or the date that the VA first notifies a veteran of his or her service-connected disability rating. If a vocational rehabilitation counselor, or a VRC for short, determines that a veteran has a serious employment handicap, then the basic period of eligibility can be extended.
So what happens after eligibility is established?
After eligibility has been established for this program, the veteran is scheduled to meet with a VRC for a complete evaluation to determine if they are entitled for such services. This comprehensive evaluation is very important. It includes several assessments, such as an assessment of the veteran's ability, aptitudes, and interests, an assessment of whether service-connected disability impairs the veteran's ability to find and/or hold a job using the occupational skills he or she has already developed, and vocational searching and developing goals which lead to employment and/or greater independence in the veteran's daily living at home and in the community.
All right, so what happens then?
If an employment handicap exists, a VRC works with the veteran to complete a determination. An employment handicap exists if the veteran's service-connected disability impairs his or her ability to get and continue to keep a job, continue working in a job. Entitlement to services is established if the veteran has an employment handicap and is within his or her 12-year basic period of eligibility and has a 20% or greater service-connected disability rating. If the service-connected disability rating is less than 20%, or the veteran is beyond the 12-year basic period of eligibility, then a serious employment handicap must be found to establish employment to vocational rehabilitation and employment program services. A serious employment handicap is based on the degree and complexity of services required to help a veteran overcome the significant restrictions caused by his or her service and non-service connected disabilities, permitting the return to a suitable employment.
What happens after the entitlement determination is made?
The veteran and the VRC work in collaboration to determine transferable aptitudes, skills, and interests, identify viable employment and/or independent living service options, explore labor markets and wage information, identify job characteristics such as physical demands of a job, search for vocational options to identify a suitable employment goal, select a vocational rehabilitation and employment program track leading to an employment or independent living goal, explore training requirements, discover resources for achieving rehabilitation, and create an individualized rehabilitation plan for the veteran to achieve the known employment and independent living goals. In addition, it is important to know what a rehabilitation plan is. It is an individualized written plan of services that delineates the resources and criteria that will be used to achieve employment or independent living goals. The plan is a signed agreement signed by the veteran and the VRC. It is updated as whomever is needed to help the veteran achieve his or her goals.
Okay. Is there anything else regarding this program that anyone else would like to add?
Yeah, so I think it's important for veterans to know that depending on their circumstances, they'll work with their VRC to select one of the following 5 tracks of services offered, which are self-employment, reemployment with a former employer, direct job placement services for new employment, employment through long-term services, including OJT, college, and other training, and independent living services. And after a plan is created and signed, a VRC or a case manager will keep assisting the veteran to work out the plan in order to hopefully achieve suitable employment and/or independent living. The VRC or case manager will provide assistance, coordinate services such as tutorial assistance, training and job-seeking skills, medical and dental referrals, adjustment counseling, payment of training allowance, ongoing counseling if applicable, and other services that may be necessary that the veteran can achieve rehabilitation.
All right, thank you. This concludes our panel discussion. We hope you found this video to be informative, and thank you all for listening.